Members, take your seats. The Judiciary Committee is back in order after recess. Members, we've got the two gun bills on the calendar today, and both authors are already up here. And we're going to start with Representative Pinto's bill, HF 8, and that after that we'll move to Representative Richardson's bill, HF 9. Members, the only reason, in retrospect, after reviewing this, HF 8 probably shouldn't even be here because of the scope of what is the jurisdiction of this committee was pretty much covered in public safety for 5 hours. So, but if we took it off the agenda, y'all would freak out and think we're doing something sneaky. So we didn't. We kept it on. However, the testimony is going to be restricted to the appeals process for denial of license transfer starting at line 3.22, hearing upon denial of transferee permit, and subdivision 13, line 7.2. That said, most of the testimony that I heard the other night was pretty similar on both bills. It was just a general objection or a general support of the bills. So if you did come, you can save that testimony, and we'll be going into great detail on HF 9. Okay. So that said, Representative Pinto, you're up first, and who's moving his bill? HF 8. Representative Considine moves that House File 8 be recommended to be referred to the Ways and Means Committee. Representative Pinto, we have the bill before us, and there is an amendment. Is that right, the A16?
That is correct, Mr. Chair.
Who's offering this? Representative Carlson moves the A16 amendment. Any discussion? All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Representative Pinto, to your bill as amended.
Thank you, Mr. Chair. And I should note, I don't think that I actually have a copy of that amendment. If the page would mind bringing a copy. Oh, there we go. Oops, Representative Richardson's getting it to me. Thank you. Let's make sure that I have that. Members, many of you have heard me say before that we face an epidemic in this country. Americans die from guns at rates many times higher than people in other countries. And members, this should be unacceptable to every one of us. And indeed, Minnesotans, led by young people, are demanding action. Members, as we consider that action, we need to keep in mind that millions of Americans, hundreds of thousands of Minnesotans, use firearms responsibly for hunting, for personal protection, for sport, as a hobby. Members, we can uphold the rights of these responsible gun owners and at the same time do more to keep guns out of the hands of people who have shown themselves to be dangerous. We can do both of those things, and the bills before you tonight do both. House File 8 would require that the seller of a gun make sure, through a criminal background check, that the purchaser of the gun isn't a violent felon, a domestic abuser, or otherwise prohibited from having it. House File 9, which you hear shortly, would create a court process where someone proven to be dangerous, based on concrete evidence, could be temporarily prohibited from having a firearm. The two bills work in combination. I'm joined by the author of House File 9, Representative Richardson, and she and I will address the bills in tandem. So House File 8, the bill before you right now, again requires that a criminal background check occur when a gun changes hands. Now don't those kinds of checks occur already? Well, yeah, they do, if the seller is a licensed dealer. But sales by other people don't currently require such a check. House File 8 simply requires that all transfers of firearms have a criminal background check, of course, with plenty of exceptions, such as between family members. The way it works is currently, in order to purchase from a licensed dealer, a seller has to have a permit to purchase or a transferee permit. The bill simply extends that same requirement to purchase from a private seller, again, somebody who doesn't have a license. The buyer would have to get a permit, again, the same one they need in order to purchase from the licensed dealer, pardon me, and show it to the seller. They both keep a record of the transfer, and then they produce it, if necessary, as part of a criminal investigation. Members, criminal background checks on all sales is a proven policy. It's in use in more than 20 states. Those states have lower rates of gun death. It's also a policy with broad support from health professionals, from the Walz-Flanagan administration, from the more than 10,000 police and prosecutors who are members of the Law Enforcement Coalition in Minnesota, and more than 90% of the public according to a Star Tribune poll. Mr. Chair, I know the scope of discussion for House File 8 in this committee is quite limited. I have a number of testifiers ready to go, but they would be discussing other issues. And so instead, I'm simply going to note briefly the relevant portions of the bill per the chair's directive. And then with your permission, Mr. Chair, those testifiers are just going to be ready to answer questions or address concerns when we get to that portion of the hearing. So I would simply, Mr. Chair, just mention the sections that you've noted, just to highlight them. And then that will be the end of the testimony in favor. We'll simply stand for questions, Mr. Chair.
Thank you. Please do.
Okay. Members, lines 3.22 to 3.24 is the first section that's under the committee's jurisdiction as described by the chair. This is a section that provides for a hearing upon the denial of a transferee permit. The denial may be, the appeal, pardon me, may be made to the district court. We want to point out that is as an opportunity for court review of a denial of a permit. There's a separate discussion about the circumstances under which the permit may be denied or approved. The second section is lines 7.20 to 7.26. And again, this has to do with the appeal of a determination by chief or sheriff that the person is prohibited from possession. Again, there's an appeal that can be made to a district court, and the court is limited to the determination referenced in 7.24 to 7.26. And the final piece, Mr. Chair and members, is lines 10.16 to 10.17, which have to do with immunity from a violation of charge of violating the section that relates to transfers if the person possesses the record of transfer. And this was referenced in my overview, Mr. Chair and members, that both the seller and buyer need to keep a record of the transfer. They do not produce it to anyone else. They keep it themselves unless there's a criminal investigation, in which case they have to produce it. Mr. Chair, those are the three sections that were referenced, and this concludes the testimony in favor, and then we'll stand for questions at the appropriate time. Thank you.
Thank you very much, Representative Pinto. Are there folks, keeping in mind what I said at the beginning of the hearing, are there folks who want to speak to specifically those sections of HF 8? Like I said, you probably want to save the full course of your commentary for HF 9, which we'll be doing here momentarily. But is there anyone who wants to speak to those sections of HF 8? For or against? You're back. Come on down.
Thank you, Mr. Chair.
Welcome to the committee.
Members of the House Judiciary Committee, my name is Brian Gosch. I'm a lawyer and registered lobbyist for the National Rifle Association. I'll try to keep my remarks just to the sections you referenced.
Thank you.
The appeal sections are existing statute, but they also tie into some of the new provisions within Representative Pinto's bill in House File 8. In that section 2.20 through 3.3, and also when you look at sections, oh gosh, it's going to be
It's a little complicated.
5.28 through 6.1. These are new sections of law, give the law enforcement officers, the sheriffs, and the police chiefs a new reason to deny a transferee permit. And this kind of ties in House File 9 a bit because it brings in some of that language of a danger to oneself or others. And it's rather broad, gives a lot of subjectivity to the law enforcement officers. And so I think that would make it a little bit harder on appeal, given the language of those sections and law enforcement basically kind of working off a hunch, being able to base it on a previous contact with the person, then deny that person a transferee permit. And so for that reason and others, we would oppose House File 8. Thank you.
Thank you very much. Be down here. Any questions? Okay. Mr. Dorr? Oh, Representative Lucero, did you have a question?
Just not for the testifier.
Okay. Mr. Dorr? Come on down. Welcome to the committee. Welcome back to the committee, Mr. Dorr.
Yes, my name is Rob Dorr. I'm the political director at the Minnesota Gun Owners Caucus. I did want to point out that, again, sticking with your request to stay within the purview of this committee, the denial of the permit, this bill greatly expands the reasons why somebody could be denied a permit to purchase or a permit to carry, a permit to purchase. And with that, this kind of brings us back to where we were prior to the shall issue permit system in Minnesota in 2003, where a big catalyst for that movement was the unreasonable and really unjustified denials of people of their permits to carry, which turned Minnesota into a shall issue state. With all of these provisions, you're opening that door up again. Another issue that comes up is the appeals process is mentioned there, but what isn't mentioned is any sort of remedy for the person who's maybe wrongfully denied their permit. Under the permit to carry law 624-714, a person who is wrongfully denied a permit to carry can sue the sheriff in that instance, and should the court rule in their favor that the permit to carry was wrongfully denied, they get legal fees from the sheriff, and that provision isn't present in this. So there's really nothing stopping a police chief from denying every single permit to purchase and saying, sue me. And there's little recourse except for a lot of money for the law-abiding gun owners.
Thank you. Are there questions for Mr. Dorr? Mr. Dorr, so is that the primary, so your basis for saying this takes us back to pre-2003 is because there is no fees provision. Is that?
I believe so because, Mr. Chair, when the sheriffs have no incentive, or police chiefs in this case have no incentive to deny somebody, or disincentive rather, to deny somebody, they're more likely to be overzealous in their denials. Now, this may not be every police chief, this may not be every sheriff, but the problem was certainly there prior to 2003 with the permit to carry, and I think the problem would definitely be present under this bill.
Okay. Thank you for your comments. Questions for Mr. Dorr? Thank you for your testimony, Mr. Dorr.
Thank you. And Mr. Chair, real quick, this is Ben Gusweiler. He's from the Blaine Trap team. His commentary is a little bit outside of your scope, but that message wasn't communicated prior, so I asked the chair's leniency in letting him communicate his message.
Of course. Thank you. Welcome to the committee.
Hi, my name is Ben Gusweiler. I'm 12 years old, and I shoot trap and skeet in the Minnesota High School League. Before I shot for my sport, I played hockey. When I played hockey, I got a concussion, which made me quit hockey because I did not want another concussion. One day, when I saw a flyer in my school for a firearm safety class, I decided to sign up. I focused, worked hard, and learned responsibility and proper care with a firearm. I took all the tests and got 100%. Now let's move forward a bit. About 2 weeks later, when everything was said and done, I did the field day, and I got my firearm safety and hunter education certificate. This meant that I could go and hunt and shoot firearms. When I got my firearm safety certificate, I was open to a new world of sports hunting that changed my life forever. The summer of that year, I shot and shot and shot. This quickly became one of the best parts of my life. I met people and friends through the sport of clay shooting and learned responsibility for guns. This is a sport where in the National High School Clay Target League, 0 injuries or deaths have happened. At the same time, people are trying to make it almost impossible for me and my friends to participate in this league. This will not only hurt me and my friends, and it will make it much harder than it needs to be for future generations. Why are they not worried about other sports like hockey with 3.5 million injuries per year from Johns Hopkins Medicine.org? I simply just want this sport to be here for me and for my friends. For the ones that are babies right now, to be able to do this, to experience a sport that you can have loads of fun in, learn responsibility and how to be safe. If someone in our league does anything unsafe with a firearm when shooting, they'll be immediately taken off the range and will not be shooting for the rest of the day. If that same person decides to be unsafe again, they will get kicked out of the Minnesota Trap and Skeet League. If SF1261 and HF8 becomes the law in Minnesota, it would make things more confusing and harder than it needs to be. The rules become so confusing that my parents or my coach could accidentally be arrested for trying to help me and my friends do what we love. This law could take the fastest growing youth sport in the entire state and throw it away. All the things I worked so hard for would mean nothing. Shotguns are only dangerous if you don't know how to use them. And all this law is doing is making it complicated for young people to learn how to handle firearms safely and respectfully. Also, this law would make it so that people would be required to write a really long form just to hand it from one person to another. What happens if my shotgun breaks in the middle of a round? My coach can't hand me another gun without to use filling out all sorts of other paperwork. I could be disqualified from a round, and for why? Everyone in the sport has gone to lots of classes and took a test that lasts half a day. We compete on a range with lots of safety people. And how do these new laws help? All they do is ruin my favorite sport because people will be afraid to join. They won't be able to understand how this all works. Who can bring shotguns to the range? Who can hand them from one person to another? What kind of form do you have to fill out to hand it to someone? For the ones that play the sport, if this law gets passed, I guarantee you it will ruin for them too. In conclusion, these laws, SF1, 261, and HF8, would make everything worse for anyone who wants to shoot now and in the future.
Thank you for your testimony, Mr. Gusweiler. You did very well. Are there any questions from the committee, Mr. Gusweiler? Thank you very much. We're not going to grill you. You're 12. You did better than most paid lobbyists up there anyway. Members, please, I will tell you, I appreciate the applause from Mr. Gusweiler, but we are going to run an orderly committee, and I'll just note that there won't be any demonstrations from the gallery during the time because this is official business. Thank you. Are there anyone else who would like to speak to those sections, specifically those sections? Professor Olson, you're going to speak just to those sections?
Absolutely.
Okay. Who wants to talk? Okay, Representative Barr.
Real quick question for Mr. Gusweiler. What's your best trap round? Fantastic. Thank you, sir. Out of 25.
Professor Olson.
Mr. Chairman, Representative Pinto, members of the committee, my name is Joseph Olson. I'm a professor emeritus at Mitchell Hamlin Law School. I'm not speaking on their behalf, obviously. I've been president of the Gun Owners Civil Rights Alliance for 30 years. I've been lobbying here on gun issues for 30 years. And so I have recollection that goes back. The reason why the appeal procedure in the section that has to do with permits to purchase is so restricted or so narrow is because the only grounds 30 years ago and up until today for denying was that you were in violation of state or federal law, which is a pretty obvious, easy thing to determine. But this bill adds in that you can be denied because you're a danger to self or others. Now, that's a provision that we put in the permit to carry bill at the request of the sheriffs. No one disagreed with putting it in there. But in order to balance that off, we have a appeal procedure in the permit to carry bill that puts the burden of proof on the sheriff. They agreed to take it. It puts the burden of proof on the sheriffs by clear and convincing evidence. They agreed to carry that burden. And it provides that if the sheriff doesn't prevail, if the sheriff doesn't prevail, if the petitioner prevails, the petitioner gets legal fees for doing so. Because there's a big difference between saying, are you in violation of state or federal law, and saying, are you a danger to self or others, which opens up an enormous slew of everything from psychobabble to psychiatric evidence to statements to police across the board. The appeals section in this bill needs to be strengthened to balance off that language about dangerous to self or others. Thank you. And we oppose the bill because of it hasn't been changed.
Thank you.
And other reasons.
Thank you, Professor Olson. I did use the word psychobabble to a therapist once, and it wasn't appreciated, I found out, so it might be
I didn't
offensive.
intend for it to be appreciated.
Okay,
Mr. Chairman.
thank you. Any other questions for Professor Olson? Representative Lucero, you didn't? Okay. Did you have a question for Professor Olson? Oh, okay. Who are you?
Good evening. My name is Ben Rust. I am the general counsel for the Minnesota Gun Owners Caucus here in opposition to HF8.
Are you going to speak just to the sections that we put out there?
I will, but maybe in a
I don't like the but. Just the I will is adequate.
Yes.
Okay, go ahead then.
As Professor Olson knows, and I have nowhere near as much experience as he does, whenever you're legislating in the area of gun law, you've got an intersection between state and federal law. In my private practice, a portion of what I do is appeals for folks who are denied on a NICS check. And that's where I think that this has some potential for mischief. And you caught me unaware because I had a whole thing going on here. Now I'm
We got another bill.
testimony.
You should be here for that.
The essence of it is basically that upwards of 90% of NICS denials are eventually overturned. They're false positives. The process to appeal a NICS denial is almost completely void of due process. It's an administrative process. You send a letter and fingerprints off to the FBI, and they'll get back to you. Literally, you can't call them to follow up. There's no one that you can talk to. I have a client right now who we filed his appeal in February of 2017 and still have not heard back. I've talked to another attorney who practices in this area today, and he knows of folks who've been waiting for 4 years for an appeal of their NICS denial. And there is no effective remedy to accelerate this because it's an administrative process. If you attempt to sue the FBI to get a decision faster, your case will be dismissed by the judge because you have not exhausted your administrative remedies. The way that plays into HF8 is if I am attempting to purchase a firearm, I have to go to my police chief or my sheriff. I will get a background check that includes a NICS check. If I am a false positive and my NICS check comes back and the sheriff cannot issue me a permit or my police chief cannot issue me a permit, I have no alternative. I cannot obtain a firearm. I have to appeal the NICS denial, and that could take me anywhere from 3 months to 4 years. And there's no remedy. There's no way I can get around it. Currently in Minnesota, I can get around it. And the FBI will actually send you a letter back telling you exactly the record that they think makes you disqualified. I had a client who was actually going to be a security guard at the Dar al-Farouk Islamic Center who was denied for this very reason. He had the same name and a birth date that was 1 year off from someone who had been civilly committed 10 times. We got him cleared, but it took a while. If HF8 passes, there will be no method for them to obtain a firearm. If this guy's appeal that was going to be a security guard, if his appeal had taken 3 years, he has an avenue right now that he can go obtain a firearm legally. He is not legally prohibited. There's a mistake in a database somewhere that prevents him from doing it. He can legally in Minnesota go buy a firearm from a private seller. If you pass this bill, he can't. If you run the numbers, there were over 600,000 NICS checks run in Minnesota in 2018. If 1% of those are denied, which is the national average, that gives you about 6,000 people. If 90% of those are false positives, that's about 5,000 people a year that are being denied their Second Amendment rights incorrectly and have absolutely no way to appeal it other than to send a letter to the FBI and wait.
Mr. Rusk, can you wrap it up, please?
Yes, that's it.
Thank you very
I
much.
think that's unconscionable, and I oppose the bill. And
Thank
so
you for your
does the Minnesota Gun
testimony.
Owners Caucus. Have a good night.
That is it for testimony on those sections in opposition to House File 8. I am not aware of any other amendments on House File 8. Committee discussion. Representative Lucero.
Thank you, Mr. Chair, and I guess the question would be to the bill author. Upon the adoption of your amendment, which added clarity to a digital copy of the record for a retention requirement from both the transferor and the transferee. And then when I'm looking at the subdivision 5, the immunity section, a person is immune if they are able to produce these records. So my question is, if a person is 24 years old, and if this were to become law, and 50 years goes by, and they're now 74 years old, and during the course of that 50 years, in the case if they had a physical copy and they lost it for whatever reason, they were moving houses, or if they had a digital copy and their phone was stolen, or if it was run over and not recoverable, would that person then still be guilty then of a gross misdemeanor of the failure to be able to produce that 50 years later?
Representative Pinto.
Thank you, Mr. Chair. Representative Lucero, the requirement is to keep a copy which can be in digital form. So it is true that the requirement does continue all the way through. There's not a requirement to hang on to a piece of paper or necessarily in a phone or whatever else. And presumably, I know you're well aware that technology can continue to change. The idea was whatever the form is, there should be the ability to produce that copy. But it does continue for the extended time. It does.
Representative Lucero? Okay. Thank you. Any other discussion? Representative Grossel.
Thank you, Mr. Chair. And I guess this is just a little tidbit from some of the statements that Representative Pinto made in the beginning as far as the study that was done and as far as reference to law enforcement support. I'd just like to ask the representative, what study did you have that showed the United States is one of the highest in gun deaths? Can you reference that or tell us some place to go to find that?
Representative Pinto.
Thank you, Mr. Chair. Representative Grossel, whenever I've been looking at this, I feel like that information is all over the place. I'm happy, Representative Grossel and members of the committee, with the chair's permission, to send that information around. But I think if you just I don't think there's anything controversial about that at all, that the rate at which Americans die from discharge of firearms is significantly higher than other industrialized countries. But perhaps you have a reason to doubt that, Representative Grossel.
Thank you, Mr. Chair. Yes, I do. There are also studies out there that I'm just going to throw it out there because we're throwing studies around right now that shows that we are actually a lot lower than the rest of the world as far as gun deaths. So and I can find those studies too. In reference to law enforcement support, you said that you have quite a bit of law enforcement support, and the checking that I have done, having a lot of contacts in the Sheriff's Association and the Chiefs Association, the unions and so on, everybody I've talked to in my district and around District 1 and 2, as far as the LEOs, the chiefs, sheriffs, and just the boots on the ground officers and deputies, they are vehemently opposed to these bills. I just want to get that on the record because I know there's boards that sometimes put statements out there, but from what I'm gathering, these chiefs and some of the sheriffs have been outside of the realm of this decision making. So the ones that I'm talking to do not support these bills, sir.
Representative Mueller.
Oh.
Did you want to respond to it?
Mr. Chair, part of the reason to, if it's okay with the chair, I'd be inclined perhaps to someone from the Law Enforcement Coalition could simply come up and just confirm that support, given Representative Grossel's doubting of it.
Well, I'll tell you what, he did refer to opposition to both bills. And if they could do that testimony on the second one, that would be handy. Is that okay?
Certainly, Mr. Chair.
Representative Mueller.
Mr. Chair, thank you. So the American Journal of Medicine reports that Americans are 25 times more likely to be murdered with a gun than people in other countries, and also that the gun death rate in the United States is 10 times that of other high-income countries. Thank you.
Representative Lucero.
Thank you, Mr. Chair. Per my previous question to the bill author, a member of the audience here said that federal firearms licensed dealers, the retention period is only 20 years. So assuming that's accurate, I guess the question then I would have, Mr. Chair, for the bill author is, why is your retention a lifetime when FFL is only 20 years?
Representative Pinto.
Thank you, Mr. Chair. Representative Lucero, that's good information. I'd be happy to chat with you further about that. The concern is when someone transfers the firearm pursuant to this method, that is a really important step, right? We know that when firearms are handed over, we want to make sure that the person who's receiving it is in fact eligible to receive it, and that later on, if there's a criminal investigation, recognize that this person was not eligible to, that the seller have that information. So perhaps a 20-year period would make sense. I'm happy to talk with you further about that. But the most important point is that we want to make sure that sellers, in fact, keep those records, because right now there is absolutely no requirement, as you're aware, I believe, so long as the seller doesn't know that the person is prohibited, they can transfer that firearm, no questions asked.
Sir? Thanks. Any other discussion on House File 8 as amended? Representative Carlson.
Thank you, Mr. Chair. Representative Mueller, I was looking up some information as you were. Can you repeat, just so I make sure I heard you correctly, the gun death rate in the United States is how many times more than other countries?
Representative Pinto.
I'm sorry, to Representative Mueller.
Oh, Representative Mueller, go ahead.
Okay, thank you, Mr. Chair. Representative Carlson, so it's Americans are 25 times more likely to be murdered with a gun than people in other countries, and the gun death rate in the United States is 10 times that of other high-income countries.
Okay, so not,
Carlson.
thank you, Mr. Chair. So not 25% and 10%, 25 times and 10 times. Thank you.
Any other discussion by the committee? Chair Johnson.
Chair Lesh, I'm just looking up on pbs.org. United States is number 20 at 10.6 per thousand. That's unfortunate that it also, but it does include suicide. United States has about, or Minnesota, or the United States, in fact, has, I believe the suicide rate is 49 or about 45% by firearm. That includes those numbers. But El Salvador, the rate there is 39.2 per 1,000. The United States is number 20th. We're not up on top. We're farther down.
Chair Scott.
That was sort of my question, but I also wanted to see if there was any breakdown as to, of those gun deaths, how many of the guns were, how many of them were obtained illegally? Do you have that data?
You're asking this of who, Chair Scott?
Either one of the statisticians over there.
Okay, anyone want to take that bait?
Sorry, Mr. Chair.
Representative Carlson.
We were busy looking up statistics. We didn't hear the question.
Chair Scott, can you repeat the question?
The question was of those gun deaths that you spoke of, how many of those were caused by illegally obtained firearms?
Representative Carlson.
Mr. Chair, Representative Scott, give me a minute. We'll look that up for you. But again, to the point of this bill, this would do a great amount of good in reducing the amount of that. My understanding of this House File 8 is to require background checks, which would reduce the amount of illegal gun sales. So I appreciate your support for the bill.
Any other comments regarding House File 8 as amended? What's it? Oh, okay. Representative Considine.
What?
Do you have a question?
I did not.
Representative Robbins.
Thank you, Mr. Chair, and thank you, members. Representative Pinto, I just wondered if you or anyone else here might have the statistics on what the gun deaths are by firearms in Minnesota. We heard the national numbers on different places, but for Minnesota and also those obtained illegally. I know Mr. Representative Carlson said that the background checks would help stop illegal gun sales, but I'm not sure I understand how that would happen because right now the background checks are for legal gun sales. I don't know that it would affect illegal gun sales, so if you could explain that. Thank you.
Representative Pinto.
Thank you, Mr. Chair. So I do think, Representative Robbins, thank you for bringing that up, because I feel like that Scott brought up in the hearing a lot last week. There's, well, this is already illegal. You're making something already. No, so let's be really clear about this. The idea is the seller has the gun. The seller sells the gun to somebody else. That person may or may not be a prohibited purchaser. There is nothing illegal about that transfer so long as the seller doesn't know the person is a prohibited purchaser. And so what this does is says that there should be a background check to find out, is the person in fact legally able to receive the firearm, and simply providing that requirement. So so regardless, if that term illegal transfer, we're talking about a situation where someone who is prohibited, a violent felon, a domestic abuser, not allowed to have a gun, but they can simply go and purchase a gun from a private party without there being any kind of requirement to find out, imposed on the seller, to confirm, is this person actually eligible to receive the gun? And that's that concern. I do want to note, in terms of rankings, the other countries in front of us that I've seen in that list, it's true, El Salvador, Venezuela, Guatemala, Colombia, these are very great places to be. I want to point out that when you compare with countries that we would want to compare ourselves to in this statistic, Afghanistan, these are countries that I think that we probably would not want to be comparing ourselves to when it comes to rates of firearm death. So the fact we're number 20, that's true. There's 170 countries in the world, so it's true we're not number 1, but boy, we sure are up there.
Representative Robbins.
Thank you, Representative. Just to follow up, does anyone have any Minnesota-specific statistics? And also, secondly, to your point about the illegal gun sales, I appreciate that, but I wondered, is there any numbers about when felons or illegal purchasers obtain firearms now? How many of them are done through private sales versus how many are just purchased illegally, which I would expect would be the higher number?
Thank you, Mr. Chair. So, Representative Robbins, we can sort of have a sense of that from the inverse, in that there are thousands of times per year that a purchase is attempted at a dealer, so there's currently a background check, and the purchase is stopped via background check as the person is a prohibited purchaser. So that is true in Minnesota, and that's true. I mean, the thousands. I know that happens often in Minnesota. I want to be careful, especially in the evening here, about making sure that I'm getting a little bit tired. But certainly in Minnesota, and certainly in the country. So we know right now that prohibited people are going and purchasing from dealers when there's a background check, so that's stopped, that's good. So then how much more often are they purchasing in private transactions to be covered by this? And then certainly situations they're obtaining firearms that would not be, whether obtaining through stealing or other methods that folks are referring to illegal. So I don't have those numbers with me at this point. I'm kind of trying to keep a list now of points that folks have asked about to make sure to provide information afterwards to committee members. But that'd be the situation. Thank you.
Thank you.
Representative Herr.
Thank you, Chair Lesh. So I guess I would just like to, I'm a little bit troubled by this conversation we're having, just because we're, first of all, not sticking to sort of the things that we're supposed to within this committee.
That's a good point. Make a great point.
But secondly, that I think that we're talking about data and statistics when there's no way that we would ever have complete data and statistics, right? Because there's a lot of rules and laws that prohibit us from collecting actually real data. I mean, the Department of Health is prohibited from collecting data on the legal ownership of firearms. We're prevented from collecting data. And so whatever that we do have is what is actually reported, which means there are huge pieces of information missing. So we can sit here and go back and forth about whose data is more correct, but that data is already wrong and skewed to begin with, because we are not allowed in this country to collect data the way we need to actually have a comprehensive picture of the real issue here. So I would just encourage us to stick these points here, because we will fight all day on data that is already incorrectly based in how it's collected and put out there.
Thank you, Representative Herr. I think it was Mark Twain said, there's lies, damn lies, and statistics. Representative Zhang. Oh, you're not, okay. Representative Grassel.
Thank you, Mr. Chair. And I'm just looking at some data here. Got my own data, people. In 2017, Minnesota had the 11th lowest violent crime rate in the country, beating strict gun control states, Hawaii, New York, Massachusetts, and California. The 6th lowest murder rate, 8th lowest aggravated assault rate, the 18th lowest robbery rate, beating the strict gun control states of Massachusetts, Colorado, New York, Illinois, California, Maryland, and the District of Columbia. When compared with the national crime rates, Minnesota's crime rates are significantly lower and have been for decades. Minnesota's crime rates are significantly below the national average for violent crime, murder, robbery, aggravated assaults. Minnesota crime rates per 100,000 residents compared to the national crime rates 1960 to 2017. Source, FBI's Crime in the United States reports. So I can cite the source, the information, and I have yet to hear the source of the information for any stats that have come out to the contrary, sir. Thank you.
Thank you, Representative Grosso. Any other comment? Representative Herr?
Thank you, Chair Lesh. And this is not a direct response to that particular question, but I was on the Police Civilian Review Commission, and that all departments actually report differently. They're required to report different things. And so again, even though that data sounds very sound, and actually there's quite a bit of flaw in the way that so if we all really care about data, we should work on creating laws in which allow people to actually collect data in a way that we can all actually use it. And maybe that could be a conversation for another day in another committee for another bill. So I would encourage that if we all really care about the data, to look at all of the laws that are in place now so that we can't actually collect the right data and that there's no uniformity in how we ask people to collect the data, which means we'll never have the right information to look at to make a good decision. So I think that's a really big issue we should all work on.
Thank you, Representative.
Mr. Chair,
Representative Grosso.
that came from the FBI.
Okay.
They get their
So did
information from us
Waco.
first, too.
So, okay, any other comments about House File 8 as amended? I would just say before we vote on this, I used to prosecute traffic crimes when you get a hit and run. Someone show up in court and they say, well, you got your license number, and they say, I sold that car. If they say that, well, where's your transfer of title? We'd charge them with failure to transfer title and get restitution for the hit and run. You're required to do it for a car. I don't think it's that inordinate to do it for a gun. That said, some legitimate points are brought up by folks about the changing and modification of this prior to 2003. But anyway, that's all I wanted to say. With the motion, we do have two more now. They're just been popping up. Okay, Representative Lucero.
Thank you, Mr. Chair. I think I know both bill authors are up there, but I think we're on HF 8, so I would ask for a roll call on HF 8.
Roll call's been called for. Representative O'Neill.
I just wanted to respond to just your comment really quick about comparing it to car titles. The difference, I would point out, Chair Lesh, is the fact that this is held by a private person, not by the government. Not saying that we want this to be held by the government, but it's very, very different because, DVS actually holds those titles, so they have it in their database and everything else. So it's a very different thing. If I lose my car title, which actually happened during my divorce, I can go and get a hold of DVS with certain information and get the title back. There is no option for this, Chair Lesh. So this is a real problem. This is a real issue. If the only copy of it is held with the person that has the gun, then that's an issue because it is held nowhere else. And so I would point that out, that it is very different than a car title. Thank you, Mr. Lesh, or Chair Lesh.
It's a little different than a car as well, because a vehicle, you have a privilege to own a vehicle, but it's a constitutional right on the firearms.
Thanks. Seeing no other commentary, roll call has been called for. Chair votes aye.
Representative Mueller?
Yes.
Representative Scott? No. Representative Barr?
No.
Representative Cantrell?
Yes.
Representative Carlson?
Yes.
Representative Considine?
Yes.
Representative Grosso?
Nope.
Representative Hassan?
Yes.
Representative Herr?
Yes.
Representative Johnson?
No.
Representative Lucero?
No.
Representative Mariani?
Yes.
Representative Noor?
Yes.
Representative O'Neill?
No.
Representative Robbins?
No.
Representative Zhang?
Yes.
On a vote of 10 to 7, the motion does prevail, and the bill has been re-referred to Ways and Means as amended. Thank you.
Hey, members.
Okay, Representative Richardson, we have a motion to have House File 9 before us.
So moved.
Representative Noor moves House File 9. We have an amendment on this, Representative Richardson?
Yes, Mr. Chair.
How many?
One.
Okay. Do we have a motion to get the bill in the order that, it's the A22 amendment. Motion to get the bill in the order that Representative Richardson wants. Someone moves the A22. Representative Cantrell moves the A22. Any discussion? All in favor say aye. Aye. All opposed say no. Motion passes. The A22 amendment has been adopted. To your bill, House File 9 as amended. Representative Richardson.
Thank you, Mr. Chair and members of the committee. It was 21 years ago today, March 6, 1998, that 4 people were shot and killed at the Connecticut Lottery headquarters. The shooter had exhibited multiple signs of risk, and his family had contacted law enforcement with their concerns. That morning, the shooter walked into a room with his boss and shot her 3 times. He then proceeded down the hallway firing. As shots rang out, dozens of employees warned their coworkers to run into the woods as the shooter pursued them, killing 3 others. In the wake of that tragedy in 1999, Connecticut became the first state to enact a red flag law. Over 20 years later, that loss is still deeply felt in the community, and questions still remain as to whether the state could have done more to prevent the tragedy. The former Governor Malloy stated on the 20th anniversary of the tragedy, 20 years later, as we look back on the actions that occurred on that tragic day, we must recognize that our nation has not done enough to proactively work to stop the threat of situations that we've witnessed here. He went on to say that red flag policies keep firearms out of the hands of those who have shown the warning signs of being a threat to themselves or others. I strongly urge all states to adopt this critical law enforcement policy. It can save lives. A person experiencing crisis often exhibits signs that may alert others to their distress. Family members are often in the best position to see these signs of distress for individuals at risk of self-harm. According to a 2013 report by the Mental Health American, 80% of those considering suicide gave some sign of their intentions beforehand. Furthermore, there are often signs or red flags when individuals pose a danger to others. A 2018 FBI study found that active shooters displayed on average 4 to 5 behaviors that indicated they posed a danger. In many of these incidents, like the Connecticut Lottery shooting 21 years ago and last year's horrific tragedy in Parkland, people who knew the shooters observed red flags, but state laws provided no clear legal process to restrict access to guns. This is the situation right now in Minnesota, which would be remedied with the passage of House File 9. Family members who are concerned about a loved one's behavior would be able to contact law enforcement and ask for help. Law enforcement, county and city attorneys would have the discretion to initiate a petition if they agree that there's a serious safety concern. House File 9 is modeled on Minnesota's existing domestic violence order for protection process. It strikes a balance between due process in the form of a court hearing, public safety, and respect for individual constitutional rights. The bill provides for 2 forms of extreme risk protection orders. The default would be a hearing where both the petitioner and respondent have the opportunity to appear and present evidence to a judge. Judges weigh the evidence considering several indicators of crisis, including recent threats, violations of protection orders, and other risk factors. The judge must find by a preponderance of the evidence that the subject poses a risk. Orders after a hearing can last for 6 months to 2 years. Emergency or ex parte orders can last for up to 14 days and can be issued only when the judge finds reasonable grounds that the subject represents an immediate and present danger with firearms. When there is serious concern that an individual might harm themselves or others with a firearm, a legal means to temporarily remove firearms can be a prevention strategy. Many states that have passed red flag laws in the midst of grief and tragedy are forced to confront the question, could we have done more? Too many families and communities have been shattered, and it should not take another horrific tragedy for us to act. While we know that no policy is perfect, this bill will enable firearms to be temporarily removed from those who are unsafe and can be part of a strategy to fill gaps in our systems. We can be proactive as a state, and we can work to prevent homicides and suicides. And with that, Mr. Chair, I could move on to the next testifier.
Thank you. Thank you. We call your first testifier forward. We've got Commissioner John Harrington. Didn't see him in the room. Oh, there he is. He's coming around. And after that on deck is Commissioner Jan Malcolm. Then we've got Jim Backstrom, Dakota County Attorney, Jeff Potts, Bloomington Police Chief, Mary Beth Galloway, Maple Grove, and Austin Berger and New Hope. It's going to be in that order, so please be ready when the previous speaker wraps up. Commissioner, welcome back to the committee.
Thank you very much, sir.
Please state your name for the record.
I'm John Harrington. I'm the Commissioner of the Department of Public Safety.
Please proceed.
Thank you very much. There's been a very robust discussion about the facts and about different viewpoints presented here tonight. Having served for 40 years in public safety, 33 years as St. Paul police officer, the last 6 as chief of police, the last 6 beyond that as the chief of police for Metro Transit, what I can tell you that I don't think is subject to debate is that there are way too many people killed in the state of Minnesota and in my departments or in my cities by gun violence. According to the CDC, in 2015, there were 400 Minnesotans killed by gun violence. About 92, or about 25% of those were killed in homicidal action. In 2016, about 432 were killed by gun violence. And in 2017, about 465. If it's one person and it's your loved one, if it's one person and it's your partner, and I've buried 4 cops over the course of my time in the business. I've been to way too many police funerals. That's one too many. And guns are the tool used to end the lives of far too many Minnesotans. The statistics nationally, I think, are even more horrifying than Minnesota statistics. We are a relatively safe state. We have good people, and most of the times that's it may be enough. But in this particular case, in this bill's particular case, we are seeking permission for police officers who are trained to recognize dangerous situations to be able to take action to stop that danger before it ends tragically. Every day, according to the national statistics, and I want to get into a statistical debate here, 342 people in America are shot in murders. Of that 342 on a daily basis, almost 50 of those are young people, children and teenagers. Gun violence has ripped the guts out of my communities over and over and over again. I wear a band that remembers Jerry Vick, one of my great friends and a great cop, shot on the east side, not too far from where I live, trying to investigate a human trafficking case. Ron Ryan, Tim Jones, the list of cops killed by gun violence. Well, every May 15th, we sit and we read over and over and over again the litany of police officers killed in the line of duty. And the vast majority of those, I believe, are killed by gun violence. Doing nothing, I don't believe, is really an option. And so I think it's time that we take that step to say, when we recognize and when we know that somebody is a dangerous person, that we should take some action to prevent them from having a gun that can cause permanent and lethal damage. Governor Walz is supporting 2 common sense measures that together will help address gun violence in our communities. This extreme risk protection order, I believe, is a very sensible piece of legislation. It would allow law enforcement, trained cops. We spent a lot of time, a lot of money on training the cops, and we've spent even time and even more money in the last few years on trying to make sure that our cops are well trained to recognize the signs of danger. When they recognize those symptoms of dangerous behavior, they would then be empowered to alert the authorities and prevent crime. And that really has been the gold standard for policing since 1829 when Sir Robert Peel started us. First mission of police is to prevent harm. That is what our job is more than anything else. Catching the bad guys is a nice subset of that, but the primary mission is to prevent harm. Once that officer, that trained officer has recognized this danger, they would then be able to petition a third party, a neutral third party, a court, to have that individual's firearms withheld for not an indefinite period of time, but for a fixed period of time. We would then, as we do in all court cases, have to provide sufficient evidence to show that that person is a danger. So it is not simply the word of the officer, although I would, generally speaking, be willing to rely on that. But this is a fundamental right. It is what every cop, when we take our first oath of office, that first oath of office is to protect the Constitution. So this is not a right that we are moving around on without a great deal of trepidation. So we would be required to provide sufficient evidence to show that the person is a danger to themselves or others before that gun could be confiscated. The court would then have to agree, so that neutral third party, that judge sitting there in judgment would then have to agree that the individual poses that significant danger and allow for a hearing. And then through that petitioning, an extreme risk protection order could then, following due process, allow us to keep guns out of the hands of those who shouldn't have them.
Thank you. Commissioner, would you wrap it up, please?
Absolutely so. In closing, and that really is my fundamental statement here, Governor Walz, Lieutenant Governor Flanagan been very clear that this is a significant and major priority for them. Protecting the men and women who live in the state of Minnesota, protecting the men and women who protect those who live in the state of Minnesota can't wait. I do not believe that this should be delayed, and I support this bill both personally and professionally, as does the Department of Public Safety.
Thank you, Commissioner. We're holding questions till the end, members. Just to keep you apprised, Representative Richardson, we are at 6 minutes into the 15 minutes. Each side has 15 minutes to testify here, so we're at 6 minutes in. Welcome to the committee, Commissioner. Please introduce yourself for the record.
Good evening, Mr. Chair. Members, I'm Jan Malcolm, Commissioner of the Minnesota Department of Health. I very much appreciate the chance to share some public health perspective on this legislation with you this evening. We in public health are very, very familiar with the important duties that we share of protecting individual rights and the community good. Quite plainly stated, while I do appreciate that different takes are certainly possible on this issue, I believe the data are abundantly clear that this bill will save lives. I really appreciate the growing attention in our state among citizens and among policymakers to a very real public health concern in our state, which is suicide. In 2017, 465 Minnesota residents died by firearms, as Commissioner Harrington just shared with you. This 465 Minnesota deaths by firearms was comprised of 417 men and 48 women. Of those firearm-related deaths, suicide accounted for 80% of the male firearm deaths and just over half of the female firearm deaths. There were a total of 783 deaths by suicide in Minnesota. Firearms are by far the most legal and the most common method of suicide in Minnesota by a significant degree. When we look at suicide rates by mechanism, suicide deaths by firearms are 50% higher as a cause than the next most frequent means, which is suffocation, more than 3 times the rate of deaths by poisoning and 6 times the rate of all other means combined. So there's really no question but that access to a firearm is a risk factor for death by suicide. While we're not suggesting that firearm owners are more likely to attempt suicide, suicide attempts with a firearm are significantly more likely to be fatal than attempts by other means, which is a very important consideration for health providers and public health folks, because most people who attempt suicide are ambivalent about dying and decide to attempt during a short period of crisis. Therefore, reducing access to lethal means during a time of crisis can help to delay and perhaps even prevent the attempt, thereby increasing the likelihood a person will not attempt or will survive an attempt. It's important for you to know that fully 90% of those people who attempt suicide and live do not go on to die by suicide later. Rather, they find hope and help. Limiting access to lethal means is an effective strategy to reduce suicide deaths, a major problem in our state, and I urge your support. Thank you very much for your time.
Thank you for your testimony, Commissioner Malcolm. Next, we have Dakota County Attorney Jim Backstrom. Welcome back to the committee, County Attorney Backstrom. Please introduce yourself for the record.
I do have handouts that I prepared in advance in connection with the bills under consideration.
With the page, please distribute the handouts.
With you. I am James Backstrom, Dakota County Attorney. I've had the privilege of serving in that capacity for over 31 years. I'm testifying today on behalf of myself and the Minnesota County Attorneys Association in strong support of this bill. Let's be clear, the vast majority of lawful gun owners and law-abiding individuals are responsible. However, some, have committed crimes or have made credible threats of violence against others which demonstrates a danger to themselves or to others. When this has occurred, it is extremely important to the safety and security of Minnesota's residents to have a legal process in place to allow law enforcement officers or prosecutors to seek to prohibit possession of firearms by persons where credible evidence exists of such a danger. That's what House File Number 9 does in authorizing extreme risk protection orders. As proposed, this removal of firearms is subject to adequate due process protections for the individual against whom such a court order is sought. The bill clearly specifies the circumstances for which such a petition may be sought and specifies that the removal of firearms shall be for a fixed period of 6 months to 2 years, subject to renewal or extension if appropriate and necessary. If enacted, this bill will save lives in cases involving domestic violence, reduce suicides by gun, and possibly avert future mass shootings that have claimed multiple lives in schools and businesses across our state. I will just add, Mr. Chair and members, that I'm a gun owner. I support the Second Amendment. We should all value the rights and freedoms afforded by our Constitution. But with freedom comes responsibility, and that includes responsibility for our freedom to bear arms. And responsibility means the safe storage of guns and support for strengthening our laws to keep guns out of the hands of individuals who are a threat to themselves or to others. Good laws do make a difference. These small and common sense changes to our gun laws might not prevent every person who's a danger from getting a gun, but they will prevent many from doing so. And if we can save even one life by enacting legislation of this nature, it is worth it to all of us. Thank you for hearing my comments this evening. I appreciate that.
Thank you for your testimony, County Attorney Backstrom. Chief Potts.
Mr. Chair and members, for the record, my name is Jeff Potts. I am the police chief in the city of Bloomington and the current vice president of the Minnesota Chiefs of Police Association. That association represents more than 500 law enforcement leaders, including 300 active police chiefs in communities, large, small, urban, rural, and across the state. The MCPA stands in support of House File 9. We thank Representative Richardson for her hard work on this proposal. We also thank her for the recent amendments that were made to this bill. We're committed to continuing to work on the issues related to storage and firearms, as well as the language to address the process for safely surrendering firearms to law enforcement. Extreme risk orders would be used when individuals' actions or behavior have a substantial likelihood to include the use of firearms in a self-inflicted manner or against others. In these very specific situations, law enforcement or the county attorneys can file a request to the court for an order that requires the individual to temporarily surrender firearms in the individual's possession to law enforcement. The order would also prohibit new firearm purchases during the duration of the order. While we understand that this is not a panacea to solve all gun violence and violent crimes, we do think this is an important and prudent step that will help in the specific situations as well as prevent suicides. Mr. Chair and members, thank you for your time, and we ask for your support on House File 9.
Thank you very much for your testimony, Chief Potts. Mary Beth Galloway from Maple Grove. Welcome to the committee, Ms. Galloway. Please introduce yourself for the record and begin your testimony.
Thank you. Esteemed members of the committee, thank you for allowing me to speak. My name is Mary Beth Galloway of Maple Grove. I'm here tonight to tell you about my lifelong friend, Sarah, who was a victim of gun violence here in Minnesota. Sarah was my first friend. We met in preschool, jumped fences to get to each other's houses. We shared our first crush on the same neighborhood boy, and we played soccer together through high school. Everyone who knew Sarah always mentioned her contagious wide smile and a laugh you could recognize instantly because it only belonged to her. She lived her life appreciating the simple things like wearing silly socks and enjoying a good coffee. Sarah worked with children with disabilities and transitioned later into grief and loss counseling in a hospice setting. She even helped publish a grief workbook for children going through loss. Sarah was a devoted mother, daughter, granddaughter, sister, and aunt, and cherished her family. I'm here with their blessing to speak today on their behalf. January 18th, 2010 was the night Sarah tucked her son in his bed for the last time. In the middle of the night, Sarah's husband shot her and her unborn child while asleep in their bed. Then her husband turned the gun on himself, leaving their 4-year-old son alone overnight with their dead bodies. Sarah's dad arrived the next morning to babysit as Sarah was expected at the doctor for an ultrasound. When he entered the house, it was silent. He called upstairs to see if anyone was awake, and his grandson replied, "Grandpa, come. It's really bad." Sarah's family had noticed personality and behavioral changes in her husband, and they were concerned for him. That morning, Sarah's dad walked upstairs to discover his worst nightmare. The loss of Sarah has impacted everyone who knew her. Her absence is felt daily, especially by Sarah's son, who is left to navigate this world without his parents. As a mother of 4 boys, I can't even begin to understand what he went through that night and every day since. But I know no child should have to face this type of tragedy. He remembers everything from that fatal night and relives it every day.
Ms. Galloway, if you could please wrap it up.
I beg you to vote in favor of the red flag bill. Families need to have this tool in place so when they see warning signs, they can go to the police for help. HF 9 will give law enforcement the means to reduce the risk of gun deaths when people are in crisis. Sarah's mom shared this. Life is not perfect, but if we can help even one person make it another hour until hopefully things settle down in their situation, that would be a success. Sarah's family firmly believes red flag will save lives here in Minnesota. Thank you for letting me share Sarah's life with you.
Thank you for your testimony, Ms. Galloway. Austin Berger, New Hope. Austin, thank you for being here. I'm afraid you're going to have to restrict your comments to 1 minute. Thank you.
Mr. Chairman, thank you. Madam Vice Chair and members of the committee. My name is Austin Berger, and I am a sophomore at the University of Minnesota. I'm also one of the student organizers of the March for Our Lives that took place on the steps of this building last March. Members of the committee, I said this before in public safety, and I'll say it again. When most of you were in school, your first thought when you walked into a classroom was not to identify potential escape routes. It's an anxiety comparable to that which was in the back of the minds of all Americans during the Cold War. Every day when I walk into my classes, I brace myself for the possibility of an active shooter that would wreak the same kind of havoc we saw at Parkland. And our nation didn't need to lose 17 lives that day. This bill would give law enforcement officials the tools to prevent that tragedy from ever happening again. House File 9 does not violate the Second Amendment. It does not impede the constitutional right of law-abiding gun owners. It will save lives. I urge each and every one of you to support it, to be a hero, and to save lives, and to put an end to the mass killings of young people like myself before it happens in Minnesota, because we did not have the courage to act. With that, I conclude.
Thank you very much, and thank you for restricting your testimony as well, Mr. Berger. Testifiers in opposition, Brian Gosch with the NRA. And I'm sorry, did I say that right? It's Gosch or Gosch? Gosch, Brian Gosch with the NRA. Said NRA right, didn't I? Okay.
Gosh darn it. Thank you for having me here again today, members of the Judiciary Committee, Mr. Chair. My name is Brian Gosch, lawyer, registered lobbyist for the National Rifle Association. I'm going to focus on a portion of the bill that was not addressed at the last committee meetings last week when I was there also for the public safety meeting. I'm going to focus on the due process part. We do oppose House File 9. I think this has a good intention with this bill, but I think it falls short in my opinion. And one of the issues on due process is line 10.25 of the amended bill. This section requires that a respondent surrender his firearms within 24 hours of the issuance of the transfer order. It's not when the transfer order is served upon the respondent, but when it's issued. And so the time it takes for service, if the person isn't available, isn't around, can't be found, other notice can be provided, but the firearm surrender has to be within 24 hours. I think it'd be very difficult for this to happen. And it's also inconsistent with the domestic abuse statutes at 518B.01. In those statutes, a hearing has to take place first before firearms are surrendered, and the respondent then gets 3 days to surrender those firearms. And they can surrender them to a friend or relative, not just an FFL or an LEA like House File 9 requires. Because it's unlikely the firearm transfer will be voluntary within that 24 hours, I think, that results in the warrant being issued, law enforcement then exercising that warrant to seize those firearms. Elsewhere in the bill, if you look at 5.24 to 5.25, that requires the petitioner to state what firearms the respondent may have and where they may be located. So if that petition listed 4 different places, including the respondent's home, but also other people's homes, it's likely the police would execute that warrant for all those places. And then once law enforcement is rightfully within a place, anything they see in plain view is fair game. So if they go into an innocent party's home to seize the firearms of the respondent and then see substances or other things in plain view, that also can be used for a new charge, for a new crime with that person whose home they're entering. Plus, I think this bill, although it has a provision for how the respondent can get the return of firearms, does not have a provision for how the innocent owner would get firearms back from the seizure of these firearms. So in that scenario, the hypothetical that I reference, if the innocent owner has firearms seized, this is silent as to how that innocent owner gets his or her firearms back. Minnesota Constitution, Article 1, Section 7 provides, in part, no person shall be deprived of life, liberty, property, or due process of law. We think this is not providing that due process of law before seizing those firearms. The ACLU and the NRA don't agree on a lot, but on the red flag issue, we do. For example, in Rhode Island, ACLU testified against a red flag bill, stating that the low standard the bill imposed before police could apply for and obtain a search warrant against persons, inviting the police to use this bill as a shortcut for a warrant against members of minority groups suspected of being gang members or any other person the police suspect of a possible crime. ACLU went on to say, what does to stop the police from using this law in order to seize any lawfully owned firearms they have? Filing and being granted such a petition had the additional bonus of serving as a general search warrant that could conveniently allow police to stumble across evidence of unrelated illegal activity because the bill allows police officers granted an extreme risk protection order to conduct any search permitted by law. So for this reasons and others you heard last week, and I'm sure you'll hear again this week, we would oppose House File 9. Thank you.
Thank you for your testimony, Mr. Gush. Rob Dorr, Minnesota Gun Caucus. That's not what it's called, right? It's not Minnesota Gun Caucus. Minnesota Gun Owners Caucus. That's what I thought. We'll get it right next time. Go ahead. Please introduce yourself for the record, Mr. Dorr, and begin your testimony.
I'm Rob Dorr with the Minnesota Gun Owners Caucus. I'm the political director. So once again, we have numerous objections to this bill, but I'm going to try to, again, limit it within the scope of the purview of this committee here. We need to be clear about what this bill does. It uses government force to restrict civil rights. Before somebody throws out an out-of-context Scalia quote, it's important to realize Justice Antonin Scalia believed in a strict scrutiny standard. He says strict scrutiny will be applied when to the deprivation of whatever sort of right we consider fundamental. Justice Clarence Thomas also considered strict scrutiny the appropriate standard for infringements of fundamental rights. So that means that we have to go with the highest possible evidentiary standards, and that the law must be as narrowly tailored as possible to meet those to meet a compelling interest. This bill takes away a civil right, but on the preponderance of evidence of one side of the story, based on an accusation, without the opportunity for the accused to defend themselves. That's far too low of a bar to restrict a Second Amendment right, or any civil right. That's not due process. This bill essentially equates to civil asset forfeiture. But what's worse is there's not even the accusation of a crime. And it's just the suspected that a crime might happen. It's like a bad Tom Cruise movie, Minority Report, where you're trying to guess what somebody is going to do and take action prior to it happening. When you only listen to one side of the story, you don't get the full picture. Another issue with this is that false accusations only result in a misdemeanor charge. And for those of you who were in the committee last week, misdemeanor charges apparently don't even perk the ears of the county attorney. So that should provide no comfort to anybody that a false accusation would result in a misdemeanor charge when it's not going to be charged anyway. That provides a lot of that doesn't provide much disincentive for somebody to use this punitively against a friend or a family member. It's virtually impossible to prove that an accuser is lying about claims against a respondent's words, threats, or actions, unless there's physical evidence. Another thing, as school shootings were brought up, the FBI did a really comprehensive report of active shooting and school shooting incidents, and they found that there was no pattern to the pre-shooting indicators. Particularly, it's only with the benefit of hindsight that we're able to identify those indicators, and things that may seem peculiar are only red flags after the fact. And then along the lines of suicides as well, the Minnesota Department of Health, which is permitted to do firearms-related research, determined that the majority of suicides do not happen with a firearm in Minnesota. They happen with something other than a firearm, 53.4%. Now, there's a bit of a logical fallacy here when we're talking about going in with a red flag order, taking somebody's firearms, then leaving and thinking that we've somehow addressed the situation. Minnesota has the tools in law right now through 72-hour holds, through our current domestic violence statutes to help address the person in crisis. And it's important to realize that the deadliest attack on a school wasn't done with a firearm, it was done with a bomb. The deadliest attack on an entertainment venue was not done with a firearm, it was done with $5 worth of gasoline. So I hope we can all work together to roll up our sleeves to identify ways to address the persons in crisis and not believe that by depriving them of their property that we're somehow helping them.
Thank you for your testimony, Mr. Dorr. Thomas Gallagher. Please introduce yourself for the record and begin your testimony.
Thank you, Mr. Chair. Members, my name is Tom Gallagher. I'm a criminal defense attorney in Minneapolis. I represent people sometimes on gun crimes. I spent 13 years defending people in civil commitment court in Hennepin County as a court-appointed attorney, where one of the elements that have to be proved for a civil commitment is danger to self or others based on recent behavior in order to be civilly committed. This proposal does concern me because it seems very broad. It seems to be trying to address a problem of violent crime by taking away or impairing the rights of basically everybody, people that really have nothing to do with violent crime. It reminds me of the idea of locking up all males at age 16, releasing them at age 26, guaranteed to drop the violent crime rate by more than half. Would we do it? It would be effective, but would we do it? Probably not. It would be overly broad. It would not be right to do that. We should have a more narrowly tailored solution. Individual rights to weapons and self-defense are more basic than the right to vote or free speech. If we had a proposal like this to address bad speech, pre-publication censorship, how would we feel about that? Voter suppression laws come to mind as well, that the suppression of the right to vote. The right to have a firearm is similar to those fundamental rights, even more fundamental, because without the right to firearms, we wouldn't have the right to vote, and we wouldn't have the right to free speech. The law seems to invite speculation about what might happen based on fear rather than facts. We do already have Minnesota Statutes 253B for civil commitment that provides a remedy for a person who is a danger to themselves or others due to mental illness, chemical dependency, and similar things. Also, we have the OFP, Order for Protection and Harassment Restraining Order statutes that will the court can order guns to be surrendered if under either of those statutes, those procedures that already exist in law. So these are some examples of the idea that we already have many laws in place right now where if there is a problem with someone, we can already have the court address firearms if they're not safe to have firearms. We don't need a new law that is very broad when we already have existing laws that already address the problem.
Mr. Gallagher, if you could wrap up your testimony, please.
Okay, and the 624.713, ineligible person. If a person is ineligible and there's probable cause to believe they possess a firearm, the police can go in right now, arrest them, and take all their firearms. We don't need this law to do that. We can already do that right now. If they don't have a firearm, then this law shouldn't matter, this proposed law. I wanted to just touch on the preponderance of evidence standard.
Mr. Gallagher, please wrap up your testimony.
Okay. 253B has clear and convincing standard. This has a lesser standard preponderance, which is like a civil lawsuit for just like a car accident case, which is really a due process violation. Thank you.
Thank you for your testimony, Mr. Gallagher. Joe Olson, Gun Owners Civil Rights Alliance. Alliance, right? Alliance, correct. Okay, Alliance. Thank you. Please introduce yourself for the record and begin your testimony, Professor Olson.
Mr. Chairman, representatives, my name is Joseph Olson. I'm the president of the Gun Owners Civil Rights Alliance. You'll notice it says civil rights. We chose that name 30 years ago because the right to keep and bear arms is a civil right. It is a constitutional right. It is a right that you should be slow to limit. With regard to this bill, the actual statistics in November, University of California, Davis Violence Policy Research Center and the Johns Hopkins School of Public Health, which is funded by Michael Blomberg for the purpose of coming up with anti-gun research, looked at California, which has had a law like this for 10 years. 10 years. They looked at an actual law that was in place. And what did they discover? Not what they wanted. There was no change in the rates of murder or suicide in California in those 10 years because of these laws. It had, quote, no net effect. Doesn't make a difference. And we'll talk in a few moments about why that's the case. But we could also take a look at Canada. Canada severely restricted handguns in 1975. In 1977, they did a big study. And the question was, well, what happened to suicides? And they looked at what happened to suicides, and after the law was passed, suicides went down for a bit, and then they went back up. Overall, suicides did not change. Handgun suicides went down, of course. But suicide did not change. Why? Because people who are suicidal are determined to die. If you take away one mechanism, they will find another. And indeed, the data from Canada shows that that is in fact true. They will find another way. People who shoot themselves are 100% aware of the lethality of firearms. They intend to die. You take away the firearm, they will find something equally effective. My 86-year-old neighbor, 2 houses down, used clothesline from the stairway in her basement. In Canada, they found, I'll try to get my Canadian accent here, Canadians appear to have fully substituted suicide by leaping. And just a week ago, I read a news piece about a 16-year-old girl who went up to the 5th floor of a parking garage. You know how many parking garages there are in Minneapolis and St. Paul?
Mr. Chair, I'm not finding mocking suicide funny.
Okay. Well, please proceed, Professor Olson.
Yes. And she jumped off the 5th floor, taking a header into the concrete, which is pretty lethal as well. So we know from California, we know from Canada, that the claims that this law will all of a sudden provide a panacea for people who choose to kill themselves, for people who choose to murder others, it's not true.
Professor Olson, could you wrap up your testimony, please?
Oh, yeah, I'm sorry. One thing that surprised me, and which you heard several of the other witnesses mention, is the burden of proof. The burden of proof is preponderance of an evidence. And we had the chief testify, oh, I'd be willing to depend on police opinion. Well, altogether, too many judges are willing to depend on police opinion when the hurdle is only preponderance of the evidence. Could we do something else? We could look to Florida. Florida has a statute that's been in effect for about 2 years now. It's a statute that works, and they put the hurdle at clear and convincing evidence. Now, the advantage of this is it allows an elected judge to say, well, yes, I believe them, but there simply wasn't clear and convincing evidence. It's a much better standard when you're dealing with a constitutional right. We think it's the appropriate standard.
Thank you, Professor Olson.
One more thing. We have provisions already in the law, in the OFP law, for dealing with surrendered firearms. They allow a third party to maintain the firearms. Why this bill doesn't just copy what's already working in 518B.01, I don't know. But I can speculate. If you don't let a private party keep it, then you have reasonable fees being charged by the FFL and the police department. And lo and behold, in 2 years, you'll take away the gun with the fees. Thank you.
Thank you for your testimony, Professor Olson. The last testifier in opposition will be Reverend Tim Christopher, and I'm sorry, Reverend Christopher, you'll be limited to 1 minute 30 seconds. Please introduce yourself for the record and begin your testimony.
Good afternoon, and thank you for having me. My name is Reverend Tim Christopher. I'm out of Berea Missionary Baptist Church in North Minneapolis, and I just come here to say today is I'm looking for this committee to give a damn. And what I mean by that is this here. In the early 90s, we had an epidemic in the black neighborhood, and we called that crack, and nobody gave a damn. And then there become opiate problem. Everybody gave a damn. In 96, 97, 98 in North Minneapolis, we called it Murderapolis. We buried a lot of African-American men, women, and children. And all of a sudden today, when things happen outside of the realm, we want to pass bills. See, where I'm at, my church sits on Lindell and 30th, and we have to escort our women and our children out to the parking lot because of the gun battles that goes on there. Now, I don't know how many of you all has walked between Lindell and Penn Avenue on Broadway. You know what I'm talking about. There was a 13-year-old boy that got shot in the face just going to the YMCA. I'm here to ask you to give a damn. If you really want to stop gun violence, find out how a 16-year-old boy is getting a gun. Let's look at the gun flow problem going into North Minneapolis. See, we can sit here all night and come up with statistics, but when I get a call from a mother looking for her 16-year-old daughter, and I got to go on James Avenue to a drug house, and everybody in there got guns bigger than my gun, we got a problem. But it's not your problem. So y'all want to sit here and y'all want to come up with all these here data and these statistics. I'm living real life every day down there. That's where the problem is. So when you can come up with a way to keep the guns out of these thugs' hands, and you can come up with a way to make sure the people who shouldn't have a gun, the thugs, the boneheads, then you can pass a bill. But these bills don't do nothing for North Minneapolis. They don't do nothing for the black community. I'm just asking y'all to give a damn. That's all I'm asking for. See, because I fight down there all the time. I spend Saturdays walking, talking with young men, trying to get them to understand that selling on a corner isn't going to get you nowhere. And they got guns bigger than my gun. I'm a gun owner. I'm a part of Minnesota Gun Caucus. I'm Black Heritage Gun, African American. I've met with people from Mom's Demand, been in Brooklyn Park in their meetings. I know someone from every town. I'm desperate. I'm going anywhere I can to get help. But you can keep passing these here bills that ain't gonna do nothing for nobody if you want to. But if you want to stop the gun violence, let's get serious. I got cards that I can give each and every one of you. If you want to walk with me one night when I get a phone call at 1:30 in the morning, come there. But these statistics from Florida, from Venezuela, and all this here, it ain't doing nothing for y'all. Y'all just sitting here, just run off. But you really want to find out where it's happening? Come on. Come on. I see somebody walking around here right now that says, unarmed, unafraid. I would like for them people to come and stand in my parking lot in my church on a Sunday and protect us as we walk across Lindale. I just had a meeting with the Somalis right down the street there at their mosque, and they're asking, how do we keep our young boys out of this trouble, which is about to start? And I think you guys know that. So if you really want this here to end, let's get serious about gun violence. Let's get serious. See, I really don't have a dog in this fight. I'll meet with anybody. I'm a gun owner, and I got one of them ugly guns that y'all hate, them AK-40, you know. I got one of them, and I enjoy shooting it. But at the end of the day, I got to speak for my people. I got to speak for the black people that's down there that's dying every single day. There was a young lady that was shot by a man in the parking lot, her boyfriend. We went and we got a restraining order for her. He was a felon. He found a way to get a gun. He shot her in the parking lot of Walgreens right there on Lindale and Broadway. Now, you explain to me how he got that gun. Because that bill that you about to put down there ain't going to keep a gun out of his hand. The bill that you just had a few minutes ago, not going to keep a gun out of his hands. So if y'all want to get real, let's go for where the real gun violence is. See, y'all just playing around. Come hang out with me one day. Thank you.
Thank you for your testimony, Reverend Richardson. And we went way over. Members? We went way over on the opposition time, but I wasn't about to cut him off. Committee discussion. Representative Grossel.
Thank you, Mr. Chair. And he just hit the nail on the head. The Reverend just hit the nail on the head. And that's what I've been saying a whole lot, all along here, is that if we want to get serious about violent crime, this isn't the way to do it. These bills aren't the way to do it. We have violent crime across the board against our children. Child molestation, child pornography, criminal sexual conduct, all the way across the board. Violent crime, period.
Thank you, Representative Grossel.
And I just had a couple more things for Chief Potts. Chief Potts, we both been in the blood and the mud, but I have to disagree with you on the support that you say is there for these bills. Chiefs of police in my area do not support it. And for the commissioner, I mourn the losses of our fallen officers, just same way as you do. Since I've been able to serve down here in the House, I go to that memorial, and I stand there and I wonder why I'm still here. As one who's been shot in the line of duty, I get reminded of that every day from the pain in my body. And I pray for the one that tried to kill me, who was lost that day. It was a tragic death, a tragic loss to the small community that I was serving in. We have the guns, we have the laws in place to deal with these types of things. We just have to enforce them, prosecute them, and sentence those, use those laws to the fullest that we already have. And Pastor, thank you again. Thank you again for bringing just the brutal honesty to this committee.
Representative Grossel. Representative Robbins.
Thank you, Mr. Chair. Thank you to all the testifiers. One of the things I heard over and over was just the need to have people bring awareness to when someone seems in crisis, and I understand that, but I don't even remember who said it honestly, but the 72-hour hold rule is already there, and the domestic violence provision is there, and I think that use of the 72-hour hold rule, if you know of someone in crisis, is a much better way to go, because not only could they get the firearm away if that's it, but some other means, but they also get evaluated for mental health. And I think in a crisis, this person needs treatment and they need medical evaluation. They don't just need their guns removed. And so I think maybe better understanding of the use of the 72-hour hold and helping schools understand that's an avenue if teachers know that, or families. But I think that is already in place, and that avenue of working on providing evaluation and treatment for the person, not just taking away the guns, is much more about addressing this situation. And so I think that is probably a better way to address the mental health crisis part of this discussion.
Thank you, Representative Rob.
Mr. Chair.
Go ahead, Representative.
I agree with you that we need to do work on our mental health system, because we know that there are huge gaps, I think, within our mental health system as well. I was just at Regions a little over a week ago with a family where someone had a suicide attempt, and there were no beds available for that 72-hour hold. And the unfortunate challenge with our current mental health care system is the fact that people are waiting days for beds. Some people are being released early from 72-hour holds because there are not enough beds available. And from a provider perspective, at every level, there are not enough providers. There are not enough psychiatrists. There are not enough social workers. There are not enough nurses. From a psychiatrist perspective, here in the metro, families can be waiting 3 to 4 weeks to be seen by a psychiatrist. If you're going out to rural Minnesota, there have been waits that have been up to a year to see a psychiatrist. And so I think that as part of this discussion, we also need to talk about how do we fill in those gaps within the mental health system as well, because I agree with you that that's a very important piece of this as well.
Thank you, Representative Chair Scott.
Thank you, Mr. Chair. And I did have a question for either Chief Potts or the county attorney that testified.
I want you to come on up, Chief Potts. Well, which one do you want?
Chief Potts is already
Come on up,
standing.
he's closer. Go ahead, ask your question, Chair Scott.
Thank you, Mr. Chair. I've been contacted by some law enforcement folks in my community, and they are concerned about the responsibility on law enforcement to go out and retrieve these firearms, especially if you're going to see someone that is not in a good place, perhaps mentally. And so when I was working on the body camera legislation, I was told by law enforcement that inside a person, because I had a problem with the camera being on in somebody's home and so forth, and I was told that being inside someone's home is one of the most dangerous places for law enforcement. So are you okay with this bill? Do you think well, first of all, are you okay with the rank and file going into people's homes to confiscate these firearms?
Chief Potts.
Mr. Chair and Representative Scott, I think as we've worked to develop this, and even the amendments that were added today that direct the post board to help develop model policies and procedures for how these orders are carried out, it's certainly the preference that the firearms are surrendered peacefully, perhaps at the police department. I don't think anybody wants to have to go into someone's house to try to retrieve the firearms. Our preference, in the way this bill has been written, is that they're peacefully surrendered pursuant to the order.
Thank you, Mr. Chair. Well, what if that's not the case? Because I think that there may be some cases here where people are not going to surrender their firearm peacefully if they're in the middle of a mental crisis. And they might be ticked off that their firearms are being taken away from them to boot. My concern here is putting law enforcement in harm's way unnecessarily. And when I look at the track record of the work that we did, I think it was in 2014 or 15 on domestic abuse orders and how little that's been followed up on, the Carrie Levin story that talked about that there were 2,937 OFP cases statewide that automatically required gun transfers, and only 119 of them had the firearm transfer affidavit on file in the court. So we're not even, that's 96% of the cases that the law is not being followed up on. And so I don't understand how this bill is going to be any different. So if someone at the table wants to take a swing at that.
Go ahead, Richard.
Thank you, Mr. Chair. As part of some of the research in terms of thinking about officer safety and what this process can look like, I had the opportunity to talk with officials in San Diego. San Diego, for the last year and a half, have been working closely with law enforcement to conduct these orders. And in the time period when I had talked to them, they had conducted 120 of these orders so far. And what I thought was very interesting about their approach, they also agreed that going to someone's house could increase risk for officers. And so they were using approaches of actually approaching people on the street. So they would have a traffic stop or approach individuals within the community, and really thinking about having a de-escalated conversation with individuals. And they really framed it as sort of a cooling off period when they were talking with these individuals. With 120 of those cases, 119 of them, individuals willingly surrendered their guns to law enforcement based upon that conversation. And there was only one instance that required sort of this SWAT-like show of force in terms of going into someone's home. So there's a spectrum of ways that law enforcement would be able to work with in terms of processing those orders.
Thank you, Mr. Chair. And I think we're comparing apples to oranges when we're talking about the difference between California and Minnesota. It's already a highly regulated place. So I don't know. I'm really uncomfortable, and I look at this new language, and it says that the Post Board shall develop model procedures and standards for storage of firearms. It's not saying that's the procedures are, the way I read it, in relation to the storage of firearms, not the procedure of going actually into a home and getting the firearm itself.
Who are you asking that,
Chief Potts.
Chief Potts, go ahead.
Mr. Chair, Representative Scott, I mean, there's still aspects to this bill that we're still working with the author to try and to figure out how we can do this best in the safest possible way. As I mentioned before, I think our preference is definitely has been the case in California, and the vast majority where it's a surrender, a safe surrender outside of the home. Ultimately, law enforcement has at times a very tough job to do, and if someone is, in a situation where they've now been on that end of an extreme risk order, they must be a danger to themselves or others, and I think we're going to have to figure out how to separate that person from firearms. I think that is the issue, whether it's towards law enforcement or themselves or someone else. That is our goal in preventing that. Law enforcement is getting really good at de-escalation tactics and techniques, and really thinks through how are we going to handle this situation in a safe manner, and we will do everything we can to make sure that situation goes as safely as possible.
Chair Scott, last question.
Last question, thank you. And this is to the bill's author. So if we're seeing in cases where OFPs there's been a hearing and an OFP has been issued, and these orders for protection, the firearm transfers are not being followed up in those cases, what makes you think that this law is going to be followed up on as well? When people are having ex parte orders, they're not even aware that that this is happening to them in some cases. As was previously pointed out, the 24 hours, those people may not even know that an attempt for service was made. So how are we going to, what's your answer to that question, I guess? Thank you.
Representative Richardson.
Thank you, Mr. Chair. And, you know, there are 13 states that have passed red flag laws so far, and I think there's an opportunity to learn from some of those other states. And what I found in my research in terms of thinking about how you develop model policies and procedures related to this, where it has worked best is in situations where law enforcement is working very closely with the county and city attorneys to process the orders. And there are some states that sort of struggled to with the process, and I think that San Diego was one of those. But in the last year and a half, they have they figured the process out, and about a quarter of the orders that they have served have been for people who were at risk of self-harm. And one of the things that they noted that was surprising to them are the number of people who have come back to thank them for helping them when they were in helping them when they're in a moment of crisis. And you know, I would also note, I think it was Professor Olson who talked about the red flag law in Florida, for example, and he said that was working very well there.
Thank you, Representative Richardson. On the list is Representative Moeller, Herr, Noor, O'Neill, Johnson, Lucero, Carlson, Hassan, Consign. It'd be easier to make a list of who's not going to speak on the committee. Go ahead, Representative Muller. Oh, Barr, okay.
Thank you, Chair Lesch.
Oh, you're not speaking. Okay.
I have a question for Representative Richardson and for County Attorney Backstrom, so if he wants to come on down while I'm asking my question of Representative Richardson. But I just want to make clear that it's my understanding that this bill not only is going to be removing firearms, but also if somebody has this protective order, that they're going to be notifying basically for a background check purposes, so that it would prevent someone from being able to then purchase a gun during this crisis period. Is that correct?
County Attorney Baxter. Oh, this is.
Or this is for
Representative Richardson. Go ahead.
Thank you, Mr. Chair. Yes, that is correct. And one other thing that I would add as well, there's nothing in this bill that would prohibit other action by the courts as well. So if there was a need for a concurrent transport to the hospital for a potential 72-hour hold, or if there was a crime that was committed in connection, you know, with a particular order, that could also be done simultaneously.
Okay, great, thank you. And then before I ask Mr. Baxter my next question, I just wanted to comment on something. I think it was the defense attorney Gallagher had said about doing civil commitments, and I think he said in Hennepin County, and Hennepin County is where I work when I'm not here, and we have a very secure building, and we have a secure building there because there was a fatal shooting in the government center, and that shooting was one that would have, this kind of law could have really potentially prevented. And I talked about the victim in that case at the last hearing, Shelley Joseph Cordell, and her niece tells me that the woman who shot her in the government center had been threatening her. There was a lot of threatening behavior. Shelley had gone to the police. They said that there was nothing that they could do until this person actually hurt Shelley. And her niece says that had Minnesota had a law like this, she knows Shelley would have used it. So I just wanted to make that comment, but also ask you, Mr. Backstrom, there's been a little talk today about what laws are in place and what laws aren't in place. And so if you could just clarify for us what laws currently exist for prosecuting folks that shouldn't have a gun.
County Attorney Backstrom.
Thank you, Mr. Chair. Representative Moeller, first of all, for anyone who's in possession of a firearm that's been convicted of a prior felony level offense, that's a felony offense when that occurs, with 0 to 15 years. Carries a 5-year mandatory minimum sentence, which can be waived for a first offense, but not for a second offense. It's ranked as level 6 under sentencing guidelines. Possession of a firearm by an ineligible person who's been convicted of a nonviolent felony offense, certain misdemeanors and gross misdemeanor offenses, including controlled substance crimes, domestic violence-related offenses, or anyone who's been civilly committed for mental illness or chemical dependency. That would be a gross misdemeanor offense under those circumstances if those individuals are in possession of a firearm. And anyone who unlawfully transfers a firearm to an ineligible person, that is a felony, a 5-year felony with no minimum sentence under the law.
Representative Mueller?
Thank you so much. And so, in your opinion, and given the laws that we already have, why do you think that this bill that we're talking about now, House File 9, is necessary?
County Attorney Baxter.
Mr. Chair, Representative Mueller, I believe this is a very important bill in terms of ensuring that when there is credible evidence, and again, that's what this bill requires, credible evidence by a law enforcement officer based upon prior law enforcement contacts or information that they've gained in connection with an individual, which indicates that that person is a danger to themselves or others, that will give the law enforcement officers the means to go and obtain this extreme protection order. And yes, we have other laws in place that some of the other representatives have referenced here earlier and so forth, and we have civil commitment laws. But some of these laws take weeks or months in order to follow these through the court process. And during that time, if we have credible evidence that there's a danger and that that person who is a danger to themselves or others has a firearm, we need to have a law in place that provides a legal process to ensure that those firearms can be removed in those situations. That's what this bill does, and that's why I think it's important and necessary.
Thank you. Representative Herr.
Thank you, Chair Lesh. So indulge me just a little bit because I'm going to tell a little bit of a story here too, and I know we're out of time, but I did hear a lot of, I heard the word civil rights come up a number of times and the seriousness we are about this particular issue. And I just want to state that civil rights in itself didn't happen with one sweeping measure, and that there were all of these things that we had to do, repeal certain laws that were discriminatory, had to put new measures into place. And so it took a really long time, and we're still working on that now. So for us to not address the gun issue and the violence around this because we can't have one sweeping measure and that one thing won't fix everything, I think is, to me, is a very weak argument. And so I would just like to put that out there. Secondly, we're talking about Second Amendment rights and about people's rights getting taken away from them. And I guess I'm a little bit perplexed because everything I read here says, like if they've, been convicted, if the person has ever been committed, if a person's been convicted, if a person's been committed, if a peace officer was informed. It goes on and on about what has already been documented. So I guess my question to Representative Richardson is that, so if I'm really upset at my husband, which we're both gun owners, I can't just go and tell somebody, I need a red flag in this guy, he shouldn't have his gun. I just can't do that, right? I just want to make sure I'm understanding this correctly, because it seems like there's confusion about people's rights getting taken away, and I just want to make sure I'm understanding this correctly.
Representative Richardson.
Thank you, Mr. Chair. So the way that the process would work, if a family member had an issue, they would be calling law enforcement, and law enforcement would be required to determine if they believe that there's credible evidence. Within some states, the way that it works is law enforcement will decide whether there's credible evidence, and if so, they'll work with a city attorney or a county attorney, or they can directly petition. In terms of thinking about, because sometimes there's a concern about someone making a false allegation to the police. I think it was in Connecticut. They've been tracking the number where they didn't follow through with the petitions, and I don't remember the number off of the top of my head, but that would be something that I would be happy to share with the committee. But the other thing that I would add is there's nothing right now that stops anyone from making a false allegation to the police. And for anyone who's been on social media in the last year, if you know the names Permit Patty, Sidewalk Sandy, Hallway Harry, I mean, there are tons of people who are making false claims, to officers. And I think what it really gets to is having accountability for that. And so one of the measures within the bill would allow for a misdemeanor. But if you're thinking about it from the court process, if you're giving false information to a court, I mean, that could also rise to the level of a felony as well.
Just one quick follow-up. And I did read here in the section around extreme risk that talked about that and going to court and what it would have to do if they couldn't reach the person and contact siblings in the last known workplace and parents and children and close relatives. I mean, it sounds like it's a pretty exhaustive list and ensuring that people's rights are not taken away from them. I did just have one. I would like to just point out one particular thing that it says here in section 2.4 that a person who's ever been, the misdemeanor. that after 3 years, right, a person may be able to, 3 years have elapsed since the date of conviction, and during that time, and the person has not been convicted again, it sounds like they have some of their rights restored in owning firearms. And I just want to point out that I was just in housing this morning, and that if a person's been, has an eviction on their record, that it's on the record for 10 years, that a person who couldn't pay their rent and was evicted has to suffer the consequences of them not being able to rent again for 10 years. And here we have people who are convicted of misdemeanor, and within 3 years they can own a firearm again. I guess I think having housing is also human rights and civil rights as well, but we actually punish them much longer than we do people who have actually committed crimes, and to have them have access to guns again is, and I don't know if maybe I'm not understanding that the 3 year correctly, Mr. Representative Richardson, is that correct in some of these, in the language here, that somebody could, again, get access, even if at one point they are not? They could not?
Representative Richardson.
Mr. Chair, so in terms of thinking about the extreme risk protection orders specifically, these are designed to be temporary in nature.
Thank you, Ms. Richardson.
Representative.
Oh, I'm sorry, one more thing, Chair Lesh.
Go ahead, Representative.
I would like to ask that, and as I conclude all this, I would like to request a roll call vote at the end of this, please.
Roll call's been requested. Representative Noor.
Thank you, Mr. Chair. Thank you to the authors, Representative Pinto and Richardson. Less than 2 weeks ago, a mother and her daughter were killed in my district, not by a gang member, but someone who they knew. This bill could have protected their lives. On Friday, 17-year-old was also killed in my district. 7 other people were shot. We've got a gun violence epidemic in this state. It doesn't matter who you look like. It doesn't matter how much you have. We're dealing with a crisis. And that crisis requires us to step up. A mother is crying. She lost her 17-year-old. I knew that kid. I'm still crying with her. He was a good kid. He was in a gang. This bill will protect those young kids. It's because we have let this system to go on and on. It doesn't matter where you live. This is just in my district. We don't talk about those issues. We need to protect lives. We're talking about people. The protection that they need to have in their lives, and making sure that that 17-year-old that was buried on Saturday could have had a better future if we had these laws in the books. We could have created a path for his mom to be enjoying. She should never have buried her son. No parent should bury their son. I've got my own kids. They live in the same place with me. I don't want them to lose their life because somebody who we did not take the proper procedures to protect the lives of my kid and my community and my many people. I don't want people to get it wrong. So members, this is an opportunity to send a message to the families, and I'm sorry for their loss.
Thank you, Representative Noor. Representative O'Neill.
Thank you, Mr. Chair. I can't remember the pastor's name from North Minneapolis. Tim? Tim Christopher. Wow. I wish he could have spoke the whole half hour. You nailed it on the head, sir. You nailed it on the head because you live it, you breathe it. Like you were saying, we should walk with you at 1 a.m. You talked about this bill isn't the answer. You're right, because I've read it. I don't know how many people in this room have read this bill over and over and over and over again. I have. And you are absolutely right. This casts not just a huge net, an enormous net. You know what I fear? The people in your community will be caught up in that net. My daughter lives in Northeast Minneapolis. I know she's across the river, but She's right here in the Metro too, 22 years old. And I fear for her too. I hear you. We hear you. Your words are some of the most powerful words that we heard tonight. I've got to guess that you've probably read this bill, studied the bill, realized that there are huge problems with this bill. There are reasons why this bill will not work. We had a couple lawyers come and explain why it doesn't work. I tried to point out last time why this bill doesn't work. And my words go unheard. I hope they listen to you tonight. Pastor, your words were incredible. I hope every person in here takes you up on your offer of walking with you side by side to see what you deal with every day. When I look at the changes that were made, it actually makes the bill worse. You know, I tried to be so incredibly clear and so incredibly precise in what was wrong with the bill, and I was ignored. I'm not just saying it for my health. I'm saying it because the bill's bad, and you've actually made it worse. And let me just give you one example of how this bill has been made worse, and the net got cast maybe in a slightly different direction, but just as wide. If we look at the amendment, I want to look at what was stricken. Let's go to page 8 of the underlying bill and then to the amendment. So it's interesting. I did say that it was rather problematic that it was included in the factors that essentially anybody with a chemical dependency would be included, that would be a factor to include. Well, that was stricken because that is literally everybody already in the criminal justice system. Every single person would fit into that category. So that was stricken, that's great. But here's what was put back in, which is just problematic in a different direction. If you look at line 1.10 through 1.13 of the amendment, which is factor number 9 that has been added in, it has lots and lots of statutory references. So I took the time to look them all up. That's what I do. That's what we're supposed to do here. Because I read the bill and I look at the statutory references and I consider and I sleep on it and I come back and I consider some more. That's what we're supposed to do. So I would like to ask the bill author, because I know I've done my homework, I know what they say. I'd like for her to tell you, the audience, and the rest of the committee, since it's her bill and her amendment, particularly chapters 257, 518, 518E, 518B, 518C. What are we including now as a factor to consider?
Oh, Representative Richardson, if you know the specifics, that's fine, but go ahead.
Thank you, Mr. Chair. The one thing that I would add is that the Factor 8, which we removed after the discussion last week, the addition of 1.9 was related to work with NAMI specifically, and so that was part of the thought process related to adding those additional pieces.
Representative O'Neill.
Okay, well, all right, Mr. Chair. Well, I guess I'll just tell you what they include. They include, I tried, a party to a pending lawsuit, a complaint or petition or other action under these sections. So, again, these are just things in process. A child custody case, a divorce case, child support case, domestic abuse, Interstate Family Support Act. Okay, so, wow. Yes, those things can be contentious, but to me that is just an interesting addition while we take out chemical dependency. The last thing I'm going to say, because I know that time is short, I would like, as I asked last time and did not get an answer, and I'm going to ask it again because it did not change. On line 7.29, this is the whole point of the bill. It is the measure by which we will start this entire process. If the author could please define what is bodily injury.
Representative Richardson? I mean, I would say bodily harm is defined in statute, so you could defer to research on that, but if you want to answer, go ahead.
Well, Mr. Chair, it's written as bodily injury.
Understood. Go ahead,
Okay.
Representative Richardson.
Yes, thank you, Mr. Chair. You know, ultimately, the intent of this legislation is to save people's lives. We know that guns are lethal, whether it's self-harm or if someone is a danger to someone else, and so that's ultimately what we're trying to do with this legislation.
Thank you. Representative O'Neill?
Well, the reason, committee, that she didn't respond to what bodily injury is because it's not defined. So we are going to start this entire process in an undefined term that's still not defined in this bill. Yes, I know what bodily harm is. That means you've caused physical pain to somebody. Physical pain. You could kick someone in the shin, you could step on their toes, you could squeeze their arms too hard, you could slap them in the back. And yeah, that's in here. But physical injury has no statutory definition. So we are literally starting this entire process on a word that's not even defined in the bill or in statute. I have a problem with that. And I pointed that out twice. And I don't know where this language came from. I don't know where this language came from. It said it was mirrored after the domestic violence statutes. It can't be because it is not written like this. I don't know where it came from, but I don't think it was Minnesota. Thank you, Mr. Chair.
Thank you, Representative O'Neill. Chair Johnson.
Chair Lesh, Representative Richardson, one thing that was brought up is it's just a temporary taking of the somebody's firearms. I'm just wondering if you can give me the definition of temporary.
Mr. Chair?
Representative Richardson.
Well, under the statute, under the emergency orders, that could be 14 days. It could also be up to 2 years.
Chair Lesh, 2 years for me, doesn't qualify as temporary. And the worst part about that, in the 2-year time period, you'd have one, maybe 2 opportunities, 1 chance per year to have an opportunity to try to get those firearms back. You could have nothing wrong, but you only have 1 opportunity every 12 months to get the firearms back. That's not temporary. Then you had the issue of the 24 hours from the order being issued to turn in your firearms. I've served a lot of domestic abuse restraining orders. From the time the judge signs it to the time it gets into the officer's hand to go serve it, it's usually 3 to 4 days. Very seldom we get them right away because they have to do the process. The court, they get signed. The court administrators have to do what they need to do. Then it goes to our civil process area. They have to do the recording of getting everything ready before it even goes into the basket where we have an opportunity to serve it in between all the other calls we have. 24 hours is absolutely ridiculous. We won't even have the papers in our hands to serve it in 24 hours. And it also says that within 5 days they have to be notified by mail. They're going to get that letter in the mail long before we even serve them the paper. It's real interesting. Then I have another issue. I'm just wondering if something happens, if an officer goes to a house, the
The person voluntarily hands over the firearms. The officer leaves. It's not a search warrant. We can't look for anything. Doesn't give one back and uses it on somebody or themselves. Is that officer going to have any exemption to any liability, or that department resolved? If the author could answer that?
Richardson.
Thank you, Mr. Chair. So with the amendment, there's actually liability protection for harm following service of an order or execution of a search warrant. So that would be lines 2.7 through 2.13 on the 822 amendment.
Chair Johnson. I'm glad to hear that, because my department has gone through that situation on a domestic abuse order. It's a serious situation. Now, with what the pastor had to say, it's real concerning. But one good thing that's come of this, I don't know if you're aware of this, BCA just let some information out. Crime is down. Let's see, I got to look up my stats again. Violent crime is been down over the last 25 years. In fact, right now, it's at its lowest level in 50 years. But we need to do more work. We need to get the firearms out of the bad people's hands. This bill doesn't do that. I'm disappointed in that. Earlier today, before we came to this meeting, it was just getting, the sun was setting. I was watching the sun on the side of the state capitol. I stood out there looking at that beautiful building, and I observed 3 flags: the state flag, the red, white, and blue of the United States, and the MIA flag, which reminded me of our veterans, what they put up with and what they did to give us our freedoms and our liberties. And now here we're discussing a bill, one that restricts one of our basic constitutional rights. It makes me really concerned what we're doing. We're looking at restricting a constitutional right, and we're not even talking about the mental health issues that we're having, which is causing this issue. And I wish we'd actually start doing going after the cause and not the tool.
Representative Lucero.
Thank you, Mr. Chair. I have a question for Rob Dorr with the Minnesota Gun Owners Caucus, if he could make his way up. But then in the meantime, I'll have a question for the bill author. As has been pointed out, both in the last committee and this committee, the particulars of the bill language are inconsistent and just poorly written, and that's been demonstrated in numerous cases. But I will just tag on what Representative O'Neill had mentioned. So if I would draw the bill author's attention to line 5.8 and 5.9. It reads, "The petitioner shall allege that the respondent poses a significant danger of bodily harm to self or other persons by possessing a firearm." Then I compare that to line 7.28 and 7.29. At the hearing, the petitioner must prove by preponderance of the evidence that the respondent poses a significant danger of bodily injury to self or others by possessing. So in other words, the petitioner must allege that they pose significant danger of bodily harm, but then there's different language, and language matters, especially when you're depriving somebody of their constitutional rights, that they simply have to pose bodily injury. So the question for the bill author is, why is the allegation and what must be proven different?
Representative Richardson.
Thank you, Mr. Chair. Thank you for pointing that out. That's information that we can get fixed.
Representative Lucero.
Well, this was pointed out, Mr. Chair, in the last committee, the inconsistencies and poorly written language. Why wasn't it fixed by this committee when it was pointed out?
I mean, that's kind of a rhetorical question. She said
Okay, so my question for Mr. Chair, for Mr. Dorr then, if he's,
Okay.
oh, did he leave?
Well, he's in the bathroom. You got another question?
I'll wait for him to come back.
Okay, Representative Hassan.
Thank you, Mr. Chair. I first want to thank the authors of the two bills. There are 34 gun deaths per day in the United States. That's according to the CDC. And if you can do the math, you can imagine how many deaths that is. If that's not an epidemic, I don't know what would be. As a mental health clinician sitting here and listening to some of the testifiers and people linking mental health to gun violence is bothersome for me. Suicide and violence are not the same. Suicide is a public health issue. Violence and homicide is an act of violence. So there is a study here that I was reading, and it's done by University of Texas, and it was published in January 2019, that declared that mental health, people who are struggling with mental illness, actually are victims of gun violence mostly. So it's not the other way around. And then some of the testifiers' testimony was that mental health is the blame, whereas gun violence should be guns. We don't have more tendency to be violent in this country. We actually have a gun problem. We have too many guns floating around. Thank you.
Thank you for your testimony, Representative Hassan. Representative Lucero.
Thank you, Mr. Chair. And my question for Mr. Dorr is, in your testimony, you made remarks something to the effect of this lack of disincentive for false allegations to be made. I just want to make sure I could hear you right, because I have a follow-up question. But if you could just repeat your comments in regards to that area.
Yeah, when the charge is only a misdemeanor charge, then there's certainly there's a low fear from the person making the accusation that they're going to be prosecuted. But beyond that, we've heard from Hennepin County Attorney Freeman himself that he won't prosecute misdemeanors, and so that there's really nothing to stop somebody from feeling like it's okay to make a misdemeanor, an accusation, a false accusation, in order to get one of these orders, because there's really no deterrent for them. There's no threat of any prosecution.
Thank you, Mr. Chair. And then in light of that fact, I just think back to this committee last night in the family law bills that we heard with gut-wrenching testimony. And then I think to just this morning, a bill that the chair was carrying, and I thought the concluding remarks from the chair were spot on. And the personal story of how there can be coaching from attorneys in this adversarial process that might cause one of the parties that are engaged in this family law adversarial engagement to perhaps step forward with allegations that might not be true. And so in light of what Mr. Dorr is saying, in the context of what we heard last night and this morning, that's a huge concern that I'm hoping that this committee takes into consideration. And Representative Herb beat me to it. I would have called for a roll call. So thank you, Mr. Chair.
Thank you, Representative Lucero. Chair Considine.
Thank you, Mr. Chair. In 1998, my wife's younger brother committed suicide. It was not with a gun. Joe Olson, your funny Canadian voice and quips about suicide were distasteful and disgusting. There was no reason for that whatsoever. Would the county attorney, Mr. Backstrom, come up?
Go ahead, ask your question while he's coming out, Chair Considine.
Would you correct what was just said about Mike Freeman's remarks, please?
Thank you, Mr. Chair. Representatives, I think there has been some misunderstanding. of my distinguished colleague from Hennepin County's testimony last week in connection with these bills. The simple fact of the matter is that Hennepin County, just like Dakota County, does not prosecute many misdemeanor offenses. Those are prosecuted by city attorneys within our jurisdictions. That's true in most of the metropolitan counties. But misdemeanors are crimes, and they are prosecuted. I prosecute misdemeanor offenses in the unincorporated areas of Dakota County, and my colleague in Hennepin County does the same thing. So there are misdemeanors that are definitely, they're crimes, and they will be prosecuted when they occur. Thank you.
Thank you. I guess I do have one other comment or question. The gentleman from the NRA, one of your concerns was that drug dealers might get busted by mistake? He said that people would have search warrants. They would go in looking for other, and might see illegal substances. That's not busting drug dealers by mistake?
Mr. Gosh, if you care to clarify.
Yes, Mr. Chair. Representative, that was just an example that I was using. It didn't have to be drugs. It could have been anything else.
So,
Chair, can I sit down?
but that would have fall on what you were saying.
Essentially, in that example, Mr. Chair, essentially the answer is yes.
Gee, I don't really look at that as being bad.
Okay, now, we got two more. We've already spoke, Representative Grossel and Chair Johnson. Before we go to Representative Carlson, who's going to be the last one, and since two of you already spoke, I'll permit one comment or question. Representative Grossel.
Thank you, Mr. Chair. I guess I want to address that liability section again, subdivision 3 in the amendment. And it'd be a question for the author. Is there any other place in statute where law enforcement officers are given this liability protection?
Representative Richardson.
Thank you, Mr. Chair. This language was based on language currently in statute where officers would seize vehicles in a DWI arrest.
Okay. Thank you. Chair Johnson.
I was wondering if Attorney Backstrom could back down for a quick question.
Chair, ask your question while he's coming down, Chair Johnson.
I tried to reiterate or explain County Attorney Freeman's statement. I'm just wondering if he could explain why there's been 0 charges for illegal transfers of firearms when we're talking about the other bill since he brought it up.
Well, Mr. Chair, Representative Johnson, I'm not aware of the facts related to that off the top of my head. I certainly do not believe that that's the case, and I'm not sure if the author has any information that could help.
Chair Johnson.
Chair Lesh, it should be 0 convictions, not charges. I'm not sure about charges, but there's been 0 convictions for illegal transfers from 2013 to present.
Okay.
Mr. Chair, if I could just add that one of the issues with though the illegal transfer is that we do have to prove as a prosecutor that the individual that transferred the gun had knowledge that they were transferring it to someone who was not entitled to possess a weapon. You know, that's not always an easy burden to meet, and in many cases it can't be met, and when a prosecutor does not have enough evidence to prove an offense beyond a reasonable doubt, then we can't file a criminal charge. And I suspect that is the problem with a large number of those offenses, and I believe that would not be a problem in connection with this particular bill.
Representative Carlson.
Thank you, Mr. Chair. I will pass on my questions and just skip to some concluding remarks as I hope we are kind of nearing the end. I want to thank Representative Richardson and Pinto. You are truly champions in carrying these bills forward. Thank you for all your hard work. Universal background checks for firearm transfers and extreme risk protection orders are common sense gun violence prevention bills. House File 8 and House File 9 will help keep Minnesotans safe and save lives. As Mr. Backstrom said, with freedom comes responsibility, and I couldn't agree more, and so do many responsible gun owners. I'm committed to addressing our nation's epidemic of senseless gun violence and fully support House Files 8 and House File 9. Thank you, Mr. Chair.
Thank you very much, Representative Carlson. Concluding remarks, Representative Richardson.
Thank you, Mr. Chair, and I will be very brief because Representative Carlson, as he eloquently stated, I just want to highlight that mass shootings make up a small percentage of the gun tragedies, and we have heard here today from the Minnesota Department of Health that nearly 80% of gun deaths in Minnesota are due to suicide, and we've heard that it's a public health crisis, and we also know that it's not distributed evenly across the state, and rural communities have a significantly higher suicide rate than the metro area. And knowing that with a bill like this, limiting access to a firearm during a time of crisis can save lives. So with that, I would ask for the committee's support. Thank you, Mr. Chair.
Thank you, Representative Richardson. Roll call's been requested. Chair votes aye.
Representative.
I'm sorry. The motion is that House File 9 as amended be recommended to be re-referred to Ways and Means Committee. Chair votes aye.
Okay, Representative Mueller,
Yes.
Representative Scott. No. Representative Barr,
Nope.
Representative Cantrell,
Yes.
Representative Carlson,
Yes.
Representative Considine,
Yes.
Representative Grossel,
Nope.
Representative Hassan,
Yes.
Representative Hur,
Yes.
Representative Johnson,
No.
Representative Lucero,
Emphatic no.
Representative Mariani,
Yes.
Representative Noor,
Yes.
Representative O'Neill,
No.
Representative Robbins,
No.
Representative Zhang.
Yes.
On a vote of 10 to 7, the motion prevails. You are on your way. Thank you, Representative Richardson and Representative Pinto.
Thank you, Mr. Chair.
Members, tomorrow's agenda will include Earn Sick and Safe Time, the tobacco, got to be 21 years old, buy tobacco. Representative Eklund, sentencing veterans. Folks, the committee still has business, so if you could take your conversations outside, please. The committee would appreciate it. Representative O'Neill's data sharing permitted to administer to disabled veterans. My bill, Legislative Commission on Intelligence, with Chair Johnson's amendment. And then the location tracking on GPS services. Oh, and we have an evening room held. Is it Wednesday today? Yeah. For Thursday night. So all you who want to get out here on Thursday night, we have an evening room held. It'd be good if we can get through it. Committee's adjourned.